May I please, Your Lordship, I beg to mention item number 7. Your Lordship, the conducting counsel, Mr. SD, is having some personal difficulty. Kindly grant us after 2 weeks.
7.
Number 7, Your Lordship.
(2017) matter.
Pardon, Your Lordship?
It's a 2017 matter.
Yes, Your Lordship.
What is it?
No, I'm not okay.
Yeah.
I'm for the private respondents.
Or is that
Expert coming.
Garo.
Lecturer.
I'll allow this time,
Yes, Your Lordship.
but no further adjournment.
Okay, Your Lordship.
If you seek adjournment next time, I'll hear only the other side and impose cause on you. Mr. Learned Counsel has some prayed for accommodation on the ground that the Learned Conducting Counsel is indisposed. It may be reminded that this is a long pending matter, and the parties are called upon to make an endeavor for the matter to be disposed of at the earliest. The prayer made for the day is granted. However, it is made clear that no further adjournment will be allowed. On prayer made, this is matter to 2 weeks.
Your Lordship.
Please, Lordship.
Your Lordship, similar prayer for item number 13 also, Your Lordship.
Item number?
13. 1-3.
Go ahead.
Mr. Hajarka?
I am 13, my lord. So here is I have got an objection, my lord, because only for produce the record. Whether matter I already pleaded of this argument.
Whether you have objection or not makes no difference, because the record cannot be produced.
Yes, they cannot be produced. So necessary order.
Counsel is not here.
Yes, please.
Your Lordship, we have received it this morning only. Then
you have received?
we need to go through it and
Then next
put
Monday,
it
my
in
lord.
order, Your Lordship.
Miss Learned Counsel for the respondent
1, 2, 3, Your Lordship.
1, 2, 3 has submitted that the records have been received only today, and as such, sometimes it's required for the same to be properly classified. It is prayed that this matter may be adjourned for the day. Pray allow this is matter to 2 weeks.
Highly obliged, Your Lordship.
Please, your lordship, it may be make 1 week, my lord. So then third week I will be out of station.
Third week will be out of station.
Yes, third week. Next week it will
So we
be.
say 2 weeks. So that is still within the third week.
Third week though I will be out of station, my lord. If it is next week, it is okay, my lord. Because only for producing the record.
This is the matter on 18th. 18th?
Okay. 1 week.
Miss 18th.
Yes, Your Lordship. Highly obliged.
Third.
May please, Lordship. Lordship, I beg to mention item number 11, Lordship, because here only just to give some produce, because the hearing was done at length, only to produce whether the subsequent during the pendency of the case another document come up, whether that is required to be challenged in a separate way or not. Only to clarify that, Lordship. I am still looking for some judgment
This is
whether
appointment
of that school teacher
in
termination because I
you,
have challenged.
you have been terminated.
Yes, after terminated.
Then somebody must have been appointed in your place.
No, they have not appointed.
Your Lordship, at length, the matter was heard, but Mr. Sangma was asked to produce some citation in support of his case.
Oh,
That one, only this one.
Still, I'm looking for some judgment, Lordship. Only to support because subsequent I challenge the dismissal order, not the termination order.
1 week.
After 2 weeks, my lord, because so many things. That's why, Lordship.
Then it will be again hard.
No. It will be there. It will not.
On pre-made by Mr. P.T. Sawal, letter counsel for the petitioner, seeking some time to file the written argument. Matter is adjourned. Recessing after 2 weeks.
Lordship. Most blessed, Lordship.
Please, Your Lordship, I beg to mention item number 10 of the hearing list, my lord. So I have a part heard matter in court number 2. That will take a little bit of time. I'm praying for some accommodation, my lord. This may come up next week.
On behalf of respondent number 1, Your Lordship, no objection, Your Lordship.
Next week.
Lordship.
On pre-made by Mr. S.N., letter counsel for the
Petitioner, my lord.
you are this
For the state,
appearing for the state.
my lord.
You are senior G
No, my lords. No longer, just J.
or just G, G appearing for the state respondent. Matter is adjourned. Recessing after 2 weeks. 1 week.
1 week, my lord.
1 week.
Obliged.
Please, Your Lordship, I beg to mention item number 9. After 2 weeks' time, Your Lordship.
On pre-made by petitioner, this is matter after 3 weeks.
Deeply obliged.
You have not been able to get the substitution.
No instruction, Your Lordship.
You
We
could have,
haven't received any instruction, Your
you
Lordship.
could have, contacted the family members if they are interested. Otherwise, you get instruction to withdraw the case.
Yes, Your Lordship.
Please.
Deeply obliged, Your Lordship.
Please, Lordship. Lordship, I beg to make a mention item 5. Lordship, I'm praying for a week's accommodation, Your Lordship.
On pre-made by the petitioner or appellant, this is matter after 3 weeks.
On daily list, item number 1.
Please, Your Lordship. I'm for the petitioner here. Same difficulty, my lords. I've expressed a difficulty for my counsels for the respondents. I have a part-heard matter, my lords. And for some reason, this matter has been coinciding with that for the last 2 or 3 weeks. If this could be taken up tomorrow or day after, I'm ready with it. But I think they have some difficulty.
We'll take it over on the 16th then.
16th, I have some difficulty, madam.
So 15th or 19th is also, it's convenient to them as well.
My 19 will be more better, Your Lordship, because I'll be out of station also. 16. 19. 19 is okay.
On pre-made by the petitioner, matter is adjourned. This is him on 19th.
19th. Highly pledged. Similar order for item number 2, my lord. These are connected.
Same order.
Obliged.
Item number 3.
in notes.
You have to, my lord, in this matter, my lord, there's certain development which has come up. I wish to file some miscellaneous application in the matter, my lord. The survey advance, we are in the process of filing it. What has happened, your lordship, is there's certain orders, my lord, restraining particularly the respondent number 7, my lord, to indulge in restraining them from indulging in any course of action as against the members of the society. Now, your lordship, what has happened is the respondent number 7, who is not represented even till today before this honorable court, they are now, my lord, forcing the members of the petitioners organization to subject themselves to the particular Dobash now, my lord. So, my lord, under such compelling circumstances, my lord, we are required to file a miscellaneous application, my lord. There is already an interim order operating. I wish to file a miscellaneous application. My lord, may kindly have this matter next week.
If there's already a order on record, then why would you want to reiterate it by a separate petition?
No, my lord, here we are making two prayers, my lord, twofold prayer. One is again restraining them, my lord. We want to bring those subsequent development on record, so that, my lord, appropriate orders can be passed as per your lordship's discretion. My lord, I am only praying that this matter be fixed next week. My lord. We are in the process of filing the application. We'll serve a copy on each one of the respondents. The matter can be taken up, my lord.
Mr. Estapa, counsel for the petitioner, has submitted that in course of these proceedings, certain new development have arisen, particularly as regard the action of the respondent number 7 herein. No ex parte order has been passed against.
No, my lord. There were ample opportunities given to the respondent
That
number
is,
7.
opportunity has been given to them to appear. They have not. They have
Yes, they have not.
I believe even notice have been issued.
Oh, sorry, my lord. I'm just being informed. On 10th of 2023, my lord, there's already an ex parte order against respondent number 7.
Who was found absent on several occasions and for which an ex parte order, for which an order to proceed ex parte against the said, for which an order dated
10/10/23.
10/10/2023 has been passed to proceed ex parte against such respondent. In view of the submission made, the prayer of the petitioner is allowed that the said application be filed within the next date fixed with advance copy to the respondents who may respond to such application if so advised. This is matter of 2 weeks.
Item number 6.
Yes,
Lordship, for this written arguments, what we are supposed to place. My written argument is ready, Lordship. Just a final correction is left out. It's ready almost. Final correction is.
on pre-made by the
But the written argument from the other side is also left.
pre-made by Ms. P. Bhattacharya, learned counsel for the applicant or petitioner.
She's the petitioner. In the Miss case, she is the petitioner.
I'm talking about the Miss case.
Yes.
Can you get Miss case? Miss case 4.
This case 4.
Seeking applicant seeking some more time to file the written argument. Seems allowed. This is matter of the 1 week.
Lordship.
Item number 8.
My lord, this is the matter where, my lord, the fresh notice was step was taken, in favor of the management authority and management, despite of receiving the notice. They are yet to appear, even today also. The matter may be proceeded for final hearing without awaiting their appearance anymore.
But they would be the principal parties.
Yes, they are the main party. Therefore, earlier also I did not press hard for hearing. They are important party, and they are very much aware. And after receiving the notice, I received an instruction from the party that the management informed them that this petitioner has filed. You go and withdraw the petition, and we can talk and settle the matter outside the court. So that was the talk. So they are very much aware of the pendency of the petition. And earlier also through the CJC, they filed the affidavit. So it is not the case that they are not aware.
See, now it's a very peculiar situation where we find from the record that counter affidavit has been filed by the said respondent 4 and 5.
Right.
When at that point of time they were represented by the CGC.
Yes, CGC.
Eventually CGC has distanced himself from these two respondents. So what would be the situation then? Would the counter affidavit file at the behest of the CGC be taken on record as part of the pleadings, or in the now? See, the present scenario is that they have failed to appear for this court. So what do we do in such circumstances? Because even if they fail to appear, if their pleadings are on record, that could have been taken to account, irrespective of the fact that they would substantiate their their submission or not on the affidavit.
Right.
But then, what do we do now?
Right. Well, since the filing of the counter is one phase of the contention of any party, and the party need to come and substantiate through oral argument, through appearances.
Exactly.
And they distance themselves, they are not doing that one. My humble submission would be the assertion made by them in the affidavit filed by the CJC need not to look into, because they are no longer interested in pursuing the matter. If they continue to pursue the matter and not opted to file a fresh affidavit, they can say that I will continue to press the affirmation made in the common affidavit. They can do that. But since now they are at all not interested to pursue the matter, so it's as good as proceeding the matter ex parte. So they are very much aware of the pendency of the litigation. Since I invoke the writ jurisdiction and they are the main party, therefore it is on my part not to press hard for ex parte final hearing. Therefore, Lordship has fixed with expectation that they may come and appear also. They are not appearing.
Sir, they have not. You try to contact them. You have appeared for them, earlier. So maybe because of your position, you could not appear, on their behalf. But at least you have contacts.
This is where last question, so I have just intimated them, but no information has come, so that's why. Because
I'm not saying officially. You do it unofficially.
I shall do.
Give them a call. Mr. H.L. Sangresu, Senior Counsel for the petitioner, has submitted that in spite of the fresh notices being served upon the respondent number 4 and 5, they have failed to enter appearance before this court. However, for ends of justice, it is prayed that another opportunity may be given to the said respondent 4 and 5 to appear for this court. On premier, this seems along. Place this matter up to 2 weeks.
Publish.
Item number 12.
this matter was heard at length by the Honorable Chief Justice, Your Lordship, and this matter has been listed here for the first time.
You expect me to?
No.
You expect me to be aware of what has been
No,
submitted?
there is a reason I want to make a mention. Your Lordship, may have it some other day. Some order has been passed. Some important issue of law is involved here.
What is the case about?
This is, Your Lordship, actually we filed a petition for quashing of this departmental proceeding, Your Lordship. Because departmental proceeding was drawn against me beyond the provision of law. There is no Meghalaya Police Act.
That would always be a stand. Otherwise, why would you come to court?
Yes, Your Lordship. For that only we.
That has been discussed by the last order at length. So, Lordship can go in leisure and maybe fix some other date after going through the order.
This court has called for the records.
Lordship, yes.
It's with you.
Lordship is recorded with us. Any other day, Lordship feels a bit, we have got a light day, any other day, we can produce a report.
On pre-made by the parties, this is matter up to 1 week.
All right.
Item number 14.
For the response.
15, 16 and 17 are connected matter, Your Lordship.
Well, these matters.
39. Yes.
These matters pertain to grant of bail by the learned special court, my lord, under NDPS Act in the matters of commercial quantity, my lord. So against the grant of bail, we have come by way of these applications, my lord, this criminal petition under 482. On the last occasion when the matter was argued, Your Lordship, we raised a query whether what are the provisions under which provision we can come before the High Court, my lord, against a grant of bail. Because we are not against violation of bail conditions. If there are violation of bail condition, my lord, then a remedy is provided under the CRPC, old CRPC, now new is come, my lord. But here we have come against the very propriety of granting bail by the learned trial court in a matter involving NDPS Act when there is a specific bar to grant of bail, my lord, especially in the matter of commercial quantity. So, I've made a compilation.
Even that aspect of, you see, the prominence of Section 37.
My lord.
The Supreme Court, in a cat-nerve judgment, I would say, has made distinction. Yeah. According to the facts and
prolonged trial, my lord.
Prolonged trial, so on and so forth, But then
these matters, in my humble submission, they are not matters of prolonged trial. That's not the ground on which the learned trial court is granted bail. Of course, the facts are different in all the 5 matters. The seizure quantity is different. The dates of arrests are different, my lord.
Not a common order.
Not a common order, my lord. The different matters.
Almost common order, Your Lordship.
In one, yours is same.
Yeah, yes, same.
Guddu Paswan is different.
Guddu Paswan is different. Here, all 4 accused persons are there, and the grounds are same, Your Lordship, for granting the bail. And here, Your Lordship, like the Section 37 says, Your Lordship, that if the court see
that, of course,
that there is no reasonable grounds, here, Your Lordship, nothing has been seized from my possession, and I was not in conscience possession. I was in different car. The contraband has been seized in truck. So they are connecting me with the truck, Your Lordship.
Those are matter of investigation.
Yes, Your Lordship. The case has been charge sheeted. The accused are not. They have enlarged on bail.
Mr. Kumar,
they are very smart, my lord. They were escorting in a red color Maruti Alto the truck, and they are taking a plea that they are in a different vehicle. My lord. They are escorting the truck right through the Assam border through Shillong, my lord.
The
So
only
that is the case.
the only you see, the only ground that you can make out is if you can find the nexus between the the parties involved, whether they have any link, the CDR and all those things have to be there.
My lord.
So
We have established that, my lord.
perhaps the what is the stage of the case now?
It's
trial is going on.
Have you
examined one witness?
Only one witness.
Have you annexed the charge sheet?
Charge sheet has not been annexed.
It has not been annexed.
Just the order, impugn order has been annexed. Only impugn order has been annexed.
That would be.
I can place the charge sheet, my lord.
You have it there?
Today is not there.
At least I think, Your Lordship, I pray, Your Lordship, the record may be called. Because here we are going to argue the matter on the merit, Your Lordship.
No, charge sheet is sufficient.
Why?
I'll place
Because
it.
so many charge sheet is required only for this court to understand the process that has taken place.
Yes, Your Lordship.
And how till the stage of passing of the impugn order.
Yes, Your Lordship.
What was the consideration before the trial court, before the
Yes, Your Lordship. Because the bail has been granted
extent,
up to charge sheet, Your Lordship.
To that extent, we'll have to
Yes,
see.
Your Lordship.
If subsequently charge sheet has been filed,
No,
or
there is
whether
only
charge
one
sheet
charge
was
sheet.
filed at that point, where that information is not here. You also have a copy of the charge sheet, would you?
My lord, on merit, we have a very simple case, my lord. On one hand, court is framing charge, my lord. That means court is satisfied that there is a prima facie material, my lord. And on the other hand, the court is granting bail under section 37 NDPS. These are inherently contradictory, my lord.
We'll look at the reasons that
We will give, when the hearing will take place, Your Lordship, I will satisfy the Honorable Court, Your Lordship, that the prima facie case and granting bail is a two different matter. There is a reasonable ground has to be there, Your Lordship, and framing the charge is only prima facie is enough.
That prima
I will
facie
satisfied.
That prima facie for framing of charge is enough for not granting bail, my lord. In my
I will
humble
come to that. I have the material, Lordship, to place before the Honorable Court.
See, if you go to section 37, I think the word used there is reasonable ground.
Yes, Your Lordship.
Is it reasonable ground or reasonable cause?
Reasonable grounds.
Reasonable grounds, Your Lordship.
So, that has been explained in many judgment of the
Judgment. And recent judgment is there, Your Lordship. 2024, I have judgment. I will come when the hearing will take place. I have the material, Lordship, to satisfy.
There are
the
reasonable grounds for believing that he is not guilty.
Yeah, that is a phrase.
Reasonable ground and prima facie is two different things, Your Lordship. And it has been explained in a constitution bench that Karnail Singh was at a state of Haryana, Your Lordship, in 2009.
You produce those when?
Anytime next week, Monday, Tuesday.
Mr. Dr. Muzika Leonard. VSGI has submitted that. Before proceeding with the hearing of this matter, the copy of the charge sheet may be and relevant papers may be allowed to be produced for this court for perusal. On primate, the same is allowed. List this matter on 18. Well, you can see well, like
15 is Monday.
So we'll do it on 16 or 18. It's up to you.
I have to go out of station. Already fixed matter on
which 16. So 18. Well, this is matter on 18.
Item number 18.
Deeply obliged.
We also more or less connected. We come together, man. So the order is different, man.
different case altogether.
It's a different case.
Then you have to produce the charge sheet of
I'll produce here also.
relating to this case. Same order, huh? Kaju.
On 18, you know,
Yeah,
same
18,
date.
Same date.
Item number 19.
Yes.
My lord, this matter pertains to the incident that had taken place in Clariot. And there's only limited issue, my lord. The prosecution had to find out whether I have been named by any of the. That is the limited.
That mob.
Yes, lordship. Yes,
assault
lordship.
case.
Yes, lordship.
Whether you have I think your case is a plea of alibi, isn't it?
Yes, my lord. There is nothing. No witnesses, my lord. Neither the call records, CDR records, my lord, of me have been collected, nor it is there on record, my lord. Just simply, randomly the order was passed, my lord, that some way through the CDR, I am connected with the instant case, my lord. That is the limited, my lord, grievances addressed before my lord.
Nobody is here. None appears for the respondent. List this matter on 16.
Congratulations.
Yeah, 16.